My name is Donald Trump. I am the President of the United States. My Executive Order number 14160 holds that the United States should no longer issue or accept documentation of citizenship for a person born in the U.S. when 1. The person's father was not a U.S. citizen or lawful permanent resident, and 2. The person's mother was either unlawfully present or lawfully but temporarily present in the United States.
This executive order violates the 14th Amendment Citizenship Clause, which states that all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States. Therefore, several district courts have issued universal injunctions, or orders that prohibit the executive order from applying to anyone in the country.
Federal courts do not have the authority to issue universal injunctions. Injunctions can only apply to the parties involved in the case, not to everyone everywhere in the United States. Therefore, I am seeking a partial stay of the injunctions, which would only enable them to apply to the plaintiffs in this case.
We'll see about that. The question before us today is whether federal courts have the authority to issue universal injunctions. And our answer is
no, federal courts do not have the authority to issue universal injunctions.
We dissent.
What? How did you make that decision?
In Grupo Mexicano de Desarrollo v. Alliance Bond Fund, we ruled that federal courts only have the authority to grant equitable, meaning non-monetary, remedies, such as injunctions, that were traditionally accorded by courts of equity when our nation was founded. Therefore, we must determine whether the High Court of Chancery in England at the time of the United States founding issued universal injunctions or analogous forms of relief. The answer is no. Suits in equity were brought by and against individual parties, and relief was only granted to those individual parties, not to everybody in the country. Courts throughout the early United States also refused to issue universal injunctions well into the 20th century. Because universal injunctions are ahistorical, federal courts lack the authority to issue them.
I dissent. Universal injunctions are not ahistorical. For centuries, English courts of equity awarded relief to parties and non-parties alike through bills of peace, in which a single case could resolve a dispute affecting an entire community. In addition, federal courts in the United States have issued universal injunctions for over a century.
But bills of peace involved small, cohesive groups and bound all members of the group, whereas universal injunctions bind only the parties to the suit. The Bill of Peace evolved into the modern class action lawsuit, not the universal injunction.
The entire purpose of equity is flexibility in situations where common law remedies cannot secure complete justice. Inflexibly requiring an exact historical match for every equitable remedy defies that flexible purpose. Besides, every court that has evaluated President Trump's executive order has deemed it unconstitutional. The order's unlawfulness is reason enough to deny the government's applications for a partial stay of the injunctions. The majority's decision invites the executive branch to enforce unlawful, unconstitutional policies, as federal courts will be powerless to stop the government's actions until every affected person somehow manages to become a party to a lawsuit and secure injunctive relief for themselves.
I agree with every word of Justice Sotomayor's dissent. Today's ruling allows the executive to deny birthright citizenship, which the founders plainly wrote into the Constitution, to individuals who have not yet sued. This decision is an existential threat to the rule of law.
When a court concludes that the executive branch has acted unlawfully, the court's answer should not be to issue a universal injunction that in turn exceeds its own power.
I concur with Justice Barrett and write separately to emphasize that courts can never award relief beyond what is necessary to completely redress the plaintiff's injuries. Relief must fall within traditional limits on the court's equitable power, and considerations such as justice for the defendant must also be taken into account.
I write separately to note two unresolved issues that potentially threaten the practical significance of our decision. The first issue is whether states have third-party standing to assert the Citizenship Clause claims of their residents. The second issue is whether district courts will attempt to circumvent the prohibition on universal injunctions by certifying nationwide classes in class action lawsuits without adhering to the federal rules of civil procedure.
I write to emphasize that this decision only applies to district courts. It remains the Supreme Court's responsibility to resolve applications for stays or injunctions regarding major new federal statutes and executive actions.
Regardless, federal courts do not have the authority to issue universal injunctions. Therefore, the government's request for a partial stay of the injunctions against President Trump's executive order is granted.
You rule, Supreme Court.
You suck, Supreme Court.